SFG Essential, Current Affairs, Polity Midterm Resignation of Vice President of India. News. The Vice President has recently resigned, leading to a rare midterm vacancy in India's second highest constitutional office. He is only the third Vice President to do so, after V.V. Giri and R. Venkataraman. Constitutional provisions for Vice President of India Article 63 provides for the office of Vice President, the second highest constitutional office, after the President. Articles 63 to 71 deal with provisions relating to the Vice President. The office is modeled on the U.S. Vice President. Midterm resignation. Under Article 67A, the Vice President may resign by submitting a written letter to the President. The resignation takes effect immediately on submission. The Constitution does not provide for an acting Vice President. However, since the Vice President is also the ex officio chairman of the Rajya Sabha, the Deputy Chairman will preside over the House in his absence. Election to fill vacancy. Article 68 of the Indian Constitution outlines the procedures for filling a vacancy in the office of the Vice President. Expiry of term. If the Vice President's term expires, an election to fill the vacancy must be completed before the term ends. Casual vacancy. In cases of death, resignation, removal, or other reasons leading to a vacancy, the election must be held as soon as possible. Unlike the President's office, where a vacancy must be filled within 6 months, the Constitution does not specify a fixed time frame for a midterm vacancy in the Vice President's office. The Election Commission of India conducts the poll under the Presidential and Vice Presidential Elections Act, 1952. By convention, the Secretary General of either House of Parliament acts as returning officer on a rotational basis. Tenure of the new Vice President. The newly elected Vice President enjoys a full 5-year term, regardless of the unexpired tenure of the predecessor. Election and eligibility. Electoral College, members of both Houses of Parliament, elected plus nominated. State legislatures do not participate. Voting. Proportional representation by means of single transferable vote through secret ballot. Eligibility. 35 years, Rajya Sabha citizen of India, minimum qualified for membership, not holding an office of profit, not a member of Parliament or state legislature. Oath. Article 69. Administered by the President or a person appointed by him/her to uphold the Constitution and faithfully discharge duties. Functions. Chairman of Rajya Sabha. Article 64 does not vote except in the case of a tie. Acting President. Article 65 discharges functions of the President in case of death, resignation, removal, or absence until a new President is elected within 6 months. Exercises full powers when the President is temporarily unable to discharge duties. Removal. Rajya Sabha resolution effective majority by a passed by more than 50% of effective strength and agreed to by the Lok Sabha by simple majority. A 14-day notice is mandatory before moving such a resolution. 6th schedule. News. Recently, Ladakh experienced one of its most severe incidents of violence in decades, driven by demands for statehood and inclusion under the 6th schedule. About 6th schedule. The 6th schedule of the Constitution, provided under Article 244, 2, and Article 275, 1, deals with the administration of tribal areas in Assam, Meghalaya, Tripura, and Mizoram. It was framed on the recommendations of the Bordoloi Committee, a subcommittee of the Constituent Assembly that examined the northeast frontier, Assam, tribal and excluded areas. Unlike the 5th schedule, which covers other tribal areas of India, the 6th schedule grants greater autonomy to tribal communities through elected autonomous councils that exercise legislative, judicial, and financial powers. Key provisions of the 6th schedule. Article 244, 2 extends 6th schedule provisions to the tribal areas of Assam, Meghalaya, Tripura, and Mizoram. Autonomous districts and regions. Tribal areas are organized as autonomous districts. The governor has the power to create autonomous district councils, ADCs, and autonomous regional councils, ARCs, in these 4 states. Governor's authority. The governor can redraw boundaries, rename, or reorganize autonomous areas. District and regional councils. Each autonomous district has a district council with up to 30 members, 26 elected by adult suffrage, and 4 nominated by the governor. Regional councils may be set up for distinct tribal groups. Legislative powers. Councils can legislate on subjects such as land, forests, excluding reserved forests, inheritance, customary laws and practices, and regulation of money lending or trade by outsiders. These laws require the governor's assent. Judicial functions. Councils may establish village and district council courts to handle disputes involving tribals. However, their jurisdiction excludes serious offenses carrying punishment of death or imprisonment of more than 5 years. Revenue and resources. Councils are empowered to levy taxes, collect land revenue, and regulate mineral resources in their jurisdiction. Administrative functions. Councils manage local services and institutions such as primary schools, dispensaries, markets, roads, fisheries, transport, and waterways. Application of laws. Acts of Parliament and state legislatures apply in these areas only with exceptions or modifications. Governor's Commission. The governor can appoint a commission to review and report on the administration of autonomous districts and regions. State river water disputes resolution in India. News. The union government will form a high-level expert committee to address interstate water issues between Telangana and Andhra Pradesh on Krishna and Godavari rivers. About interstate river water disputes resolution in India constitutional and legal framework. Article 262 of the Constitution empowers Parliament to legislate for the adjudication of disputes relating to waters of interstate rivers or river valleys. It also allows Parliament to bar the jurisdiction of the Supreme Court and other courts in such disputes. Entry 56 of the Union List provides for the regulation and development of interstate rivers and river valleys. Legislation under Article 262 River Boards Act, 1956. Authorize the Government of India to establish boards for interstate rivers and river valleys in consultation with state governments. However, no river board has been set up till date. Interstate River Water Disputes, ISRWD, Act, 1956. The primary statutory mechanism for adjudicating interstate river water disputes provides for the establishment of water disputes tribunals for resolving disputes among states regarding the sharing of river waters. 2002 Amendment introduced defined time limits for tribunal constitution and award delivery, resolution mechanisms, negotiation and agreement. States are first encouraged to settle disputes through mutual discussions. Dispute Resolution Committee, DRC. If negotiations fail, the central government may constitute a DRC, comprising a chairperson, experts, and representatives of the disputing states. The DRC seeks an amicable settlement, generally within 1 year, extendable by 6 months. Water Disputes Tribunal. If the DRC fails, the matter is referred to a tribunal. The tribunal must be constituted within 1 year of the request. It is required to give its decision within 3 years, extendable by 2 years. Tribunal awards are final and binding on the parties involved. Tribunals have been constituted for rivers such as Krishna, Kaveri, Mahanadi, Mahadevi, Ravi and Beas, Vansadhara, etc. Nominated members of Rajya Sabha News. The President of India has recently nominated 4 eminent personalities to the Rajya Sabha. About nominated members of Rajya Sabha. Source: the President of India's power to nominate members to the Rajya Sabha is inspired by the Irish Constitution. Constitution provisions. As per Article 80, the Rajya Sabha consists of a maximum of 238 elected members along with 12 nominated members. Under Article 83, the President nominates 12 individuals who possess special expertise or experience in literature, science, art, or social service. Powers and privileges of nominated members. A nominated member may join a political party within 6 months of entering the House, but will be disqualified if they do so after this period under the 10th schedule. They enjoy all the powers and privileges to which the elected members of Parliament are entitled. They can take part in the proceedings of the House in the normal manner. Voting. They are not allowed to vote in the election of the President. However, they do have the right to vote in the election of the Vice President. Note: classical dancer and theosophist Rukmini Devi Arundel was the first woman in Indian history to be nominated as a member of the Rajya Sabha. Nominations to Union Territory Assemblies. News. The Ministry of Home Affairs informed the Jammu and Kashmir High Court that the UT's Lieutenant Governor, LG, can nominate 5 members to the J&K Legislative Assembly without the government's aid and advice. Constitutional and legal provisions. The Constitution allows nominated members in Parliament and state legislatures. Anglo-Indian nominations to Lok Sabha and state assemblies were discontinued in 2020. In states with legislative councils, about 1/6 of members are nominated by governors on the advice of state councils. Rajya Sabha has 12 nominated members, appointed by the President on the Union Council of Ministers' advice. Union territories with legislative assemblies. Delhi, 70 elected members, no nominated MLAs, GNCDD Act, 1991. Puducherry, 30 elected members, up to 3 nominated by the Union Government, Government of Union Territories Act, 1963. Jammu and Kashmir, 90 elected seats, LG can nominate up to 5 members. 2 women, 2 Kashmiri migrants, and 1 displaced person from Pakistan-occupied Kashmir. J&K Reorganization Act, 2019, as amended 2023. Judicial precedents. Lakshmi Narayanan vs. Union of India, 2018 Union Government can nominate 3 members to Puducherry Assembly without UT Council of Ministers' advice. Government of NCT of Delhi v. Union of India, 2023 established the triple chain of command for accountability. LG must follow Council of Ministers' advice except in areas where Delhi Assembly has no legislative powers. Union Government stand. Nomination of 5 members to the J&K Assembly falls outside the elected government's business. Hence, the LG can nominate them without the aid and advice of the J&K government. Removal of judges in higher judiciary. News. The Union Parliamentary Affairs Minister stated that more than 100 members of Parliament, MPs, have signed a notice to initiate impeachment proceedings against Justice Yashwant Verma. The Constitution does not directly use the word impeachment for judges. However, the process of removing judges under Articles 124(4), 217(1)(b), and 218 is often referred to as impeachment. In the Constitution, the term impeachment is officially used only in Article 61, which deals with removing the President of India. Constitutional provisions on removal of judges. Article 124. For this article explains how a Supreme Court judge can be removed. A judge can only be removed on 2 grounds: proven misbehavior or incapacity. Article 124. 5. It empowers Parliament to decide the procedure for bringing such a motion and for investigating the charges under Article 124(4). To operationalize this, Parliament enacted the Judges' Inquiry Act, 1968. Article 217(1) b deals with the removal of High Court judges. It specifies that a High Court judge can be removed by the President, but only by following the same procedure that applies to a Supreme Court judge under Article 124(4). Article 218 extends the provisions of Articles 124(4) and 124(5) to High Courts, ensuring that the removal process is consistent for both Supreme Court and High Court judges. Process of removal of judges in India. 1. Initiation of motion. A removal motion must be signed by at least 100 Lok Sabha members or 50 Rajya Sabha members. The notice is submitted to the Speaker, Lok Sabha, or the Chairman, Rajya Sabha. 2. Committee formation and inquiry. If the motion is admitted, a 3-member inquiry committee is set up. The committee includes a Supreme Court judge, the Chief Justice of a High Court, and a distinguished jurist. The committee investigates the charges of misbehavior or incapacity. If the judge is found guilty, the matter moves forward in Parliament. 3. Parliamentary approval. The House where the motion originated must first pass it with a special majority. It is then sent to the other House, which also needs to approve it with a special majority. Special majority means majority of the total membership and at least 2/3 of members present and voting. 4. Presidential order. Same session. Address is once both houses pass the motion in the end presented to the President. The President issues the removal order, completing the process. Solwit Judum case, 2011. News. A group of former judges and senior lawyers condemned the Union Home Minister for misinterpreting the Supreme Court's 2011 Solwit Judum judgment. The minister said that if Justice B. Sudarshan Reddy, RETD, the opposition's vice presidential candidate, had not delivered the ruling, Naxalism would have ended by 2020. About Solwit Judum case, 2011 background. In the 2000s, Chhattisgarh became the epicenter of the Maoist insurgency. To counter this, the state government launched Solwit Judum, meaning Peace March in Gandhi, in 2005 as a state-sponsored vigilante movement. Under this initiative, tribal youth some as young as 18 were recruited as special police officers, SPOs. They were provided firearms, paid a small honorarium, and deployed as guides, informants, and fighters alongside state forces. About the petition. In 2007, Nandini Sundar, sociologist, Ramachandra Guha, historian, and others filed a petition before the Supreme Court. They challenged the constitutionality of Solwit Judum on the following grounds: Article 14, Article 21 violation of equality before law and right to life with dignity. Widespread human rights abuses, including displacement of tribal communities. Blurring of lines between civilians and combatants. Exploitation of vulnerable youth, exposing them to extreme violence without adequate training or protection. Defense of the state and union. Union government Chhattisgarh government both the defended the practice. Their arguments included SPO recruitment was voluntary, largely consisting of victims of Maoist violence, and relied on their local knowledge. The scheme provided livelihood opportunities in remote areas. SPOs were considered effective in protecting camps and resisting Maoist attacks. About the Supreme Court judgment, 2011. A bench headed by Justice B. Sudarshan Reddy delivered the judgment. The court declared Solwit Judum unconstitutional and held that deploying ill-trained, barely literate tribal youth in counterinsurgency operations was discriminatory, violated Article 14, exposing them to life-threatening risks without safeguards violated. Article 21. Arming civilians blurred the distinction between combatants and non-combatants, thereby escalating violence. Court directions immediate disbanding of Solwit Judum. SPOs should not be used in counterinsurgency operations. Only properly trained police and paramilitary forces should conduct anti-Maoist operations. Cashless bail. News. Recently, President Donald Trump signed an executive order against cashless bail in the U.S., cutting federal funding to jurisdictions that permit the practice. About cashless bail. Definition. A system where an accused is released without depositing money as bail, but with conditions to ensure they appear in court. Traditional cash bail requires an accused to deposit money or property as surety, refunded at the end of trial if conditions are met. Problem. Cash bail disproportionately affects the poor, who may remain in jail for minor offenses due to inability to pay. Purpose of cashless bail: to prevent unnecessary detention of individuals accused of nonviolent or minor crimes, while still ensuring court attendance. Bail system in India. Governed by Chapter 35 of Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023, replacing CRPC 1973. Types of bail conditions. Bond. Accused signs an agreement, often with cash deposit. Bail bond. Surety from another person with financial verification. Personal recognizance, PR, bond. Release without monetary deposit, based on trust that the accused will return for trial. Issues in India. Thousands of undertrials remain in jail despite bail due to inability to furnish surety or deposit small sums. Law Commission of India, 268th Report, 2017 said bail decisions based purely on money are contrary to constitutional ethos. Supreme Court Guidelines, 2023. If a prisoner remains in jail for over a week despite bail, jail authorities must alert the District Legal Services Authority for assistance. Chief Election Commissioner, CEC, appointment and removal. News. Opposition parties have threatened the impeachment of the Chief Election Commissioner, CEC, and action against the 2 election commissioners. About Chief Election Commissioner, CEC, appointment and removal constitutional and legal provisions. Article 324 of the Constitution and the CEC and other election commissioners, appointment, conditions of service and term of office, Act, 2023 govern the appointment, tenure, and removal of the CEC. Process of appointment, appointed by the President of India. Selection Committee. Appointment is based on recommendations from a 3-member committee comprising the Prime Minister, the Leader of the Opposition, LUP, in the Lok Sabha, and a Union Cabinet member. Conditions. Must have held secretary-level positions in the government. Should be a person of integrity with knowledge and experience in the management and conduct of elections. Tenure, 6 years or until the age of 65, whichever is earlier. Service conditions. CEC enjoys the same service and monetary benefits as Supreme Court justices. Immunity. Clause 16 of the 2023 Act protects CEC and ECs from legal action for decisions taken in office. Resignation. As per Clause 11(1) of the 2023 Act, CEC or EC can resign anytime by writing to the President. Process of removal. Constitutional and legal provision. Article 324(5) states that the CEC can be removed only in the same manner and on the same grounds as a Supreme Court judge. Section 11(2) of the 2023 Act mirrors this provision. Other election commissioners can be removed only on the CEC's recommendation. Grounds of removal. Proven misbehavior or incapacity. Misbehavior includes corrupt practices or abuse of office. Incapacity refers to inability to perform official duties. Special Intensive Revision, SIR, News. The ECI has launched a special intensive revision of electoral rolls in Bihar ahead of the November 2025 Assembly polls. About Special Intensive Revision, SIR. SIR is a focused, house-to-house verification of voters aimed at enrolling all eligible citizens and correcting inaccuracies in the electoral rolls, conducted by booth-level officers, BLOs. Objective: to ensure that every eligible citizen aged 18 and above is included in the voter list, while removing ineligible entries such as deceased or migrated voters. Constitutional and legal backing. Article 324 empowers the ECI with superintendence, direction, and control over elections, including preparation of electoral rolls. Representation of the People Act, 1950. Section 19 specifies the conditions for registration as an elector, minimum age of 18 years and ordinary residence in the constituency. Section 20 defines ordinary residence, clarifying that mere ownership or possession of a house does not make a person an ordinary resident. Section 21 authorizes the ECI to prepare and revise electoral rolls, including special revisions at any time with recorded reasons. Article 326 provides for universal adult suffrage, enabling all citizens aged 18 and above to vote unless disqualified due to criminal conviction, unsound mind, or corrupt practices. Note: historical background. Since independence, the ECI has conducted 13 intensive revisions of electoral rolls. 1952 to 56, 1957, 1961, 1965, 1966, 1983 to 84, 1987 to 89, 1992, 1993, 1995, 2002, 2003, and 2004. Immigration and Foreigners Exemption Order, 2025. News: the central government has issued the Immigration and Foreigners Exemption Order, 2025, under the Immigration and Foreigners Act, 2025. Key highlights of the order. Exemption for armed forces personnel. Indian Armed Forces personnel on official duty and their families traveling on government transport are exempt from immigration requirements. India-Nepal and India-Bhutan borders. Indian citizens entering via Nepal or Bhutan exempt. Land or air. Our Nepali and Bhutanese citizens are exempt when entering India through their borders or traveling elsewhere with a valid passport. Not applicable to entries from China, Hong Kong, Macau, and Pakistan. Tibetan refugees and minority communities. Registered Tibetan refugees in India are exempt. Persecuted minorities, Hindus, Sikhs, Buddhists, Jains, Parsis, Christians, from Afghanistan, Bangladesh, and Pakistan who entered before December 31, 2024 are exempt, regardless of travel document validity. Sri Lankan Tamils who took refuge up to January 9, 2015 are also covered. Visa exemptions also applied to holders of diplomatic or official passports under agreements, nationals from designated visa-on-arrival countries, foreign military personnel on naval warships for exercises, goodwill visits, bunkering, or disaster relief, unless notified otherwise. Appointment of state DGPs. News: the Union government has notified a single window system for appointing State Director General of Police/Head of Police Force about appointment of state DGPs. In India, the DGP is the highest-ranking police officer in a state or union territory and is also known as the State Police Chief. Procedure followed in the appointment of state DGPs. UPSC had framed guidelines for the appointment to the post of state DGPs in 2009, amended in 2023. These guidelines were made on the basis of the Supreme Court judgment on police reforms in Prakash Singh v. Union of India, 2006. According to these guidelines, states submit a list of eligible officers to the UPSC at least 6 months prior to the retirement of the incumbent DGP. Eligibility criteria. Officers must have at least 30 years of service or hold the rank of police chief, or one rank below, as prescribed for the state. However, in 2023, UPSC amended the guidelines to reduce the service requirement to 25 years. Officers with less than 6 months remaining until retirement are not eligible. The UPSC Impanelment Committee prepares a merit-based panel of 3 officers, 2 for smaller states. The state government then appoints the DGP from this panel. National Cooperative Development Corporation, NCDC. News: the Union Cabinet has approved the Central Sector Scheme, Grant in Aid to National Cooperative Development Corporation, NCDC, with an outlay of 2,000 rupees crore for a period of 4 years from 2025 to 26 to 2028-29. About Grant in Aid to National Cooperative Development Corporation, NCDC. The scheme has a total outlay of 2,000 Indian rupees crore over 4 years, 2025 to 2029, with an annual allocation of 500 rupees crore. The NCDC will manage and disburse funds, monitor projects, and recover loans. These funds will be used to provide loans to cooperatives for establishing new projects, expanding existing plants, and fulfilling working capital requirements. Grant and aid refers to payments provided as assistance, donations, or contributions from one government to another. Article 275, Statutory Grants. These grants are governed by and 282, Discretionary Grants, of the Constitution. About National Cooperative Development Corporation, NCDC. The NCDC was established by an Act of Parliament in 1963 as a statutory corporation under the Ministry of Cooperation. Headquarters, New Delhi. Objective: to plan and promote programs related to the production, processing, marketing, storage, export, and import of agricultural produce, livestock, and allied sectors based on cooperative principles. Registrar General of India, RGI, and Census 2027. News: the Registrar General of India, RGI, has urged states to achieve universal registration of births and deaths, a key step before the upcoming Census 2027. About the Registrar General of India, RGI, established under Registration of Births and Deaths, RBD, Act, 1969. Ministry of Home Affairs. Functions: Housing and Population Census, conducted under the Census Act, 1948. Civil Registration System, CRS, compulsory registration of births and deaths under the RBD Act, 1969. Other mandates: Sample Registration System, SRS. National Population Register, NPR. Mother Tongue Survey, and other demographic surveys. About Census 2027. 16th Decennial Census of India 8th, since it will be the independence. First fully digital census. For the first time, the census will be conducted through digital methods, using mobile applications, direct server uploads, and real-time monitoring. Census Operations and Timeline 2 Phases Census Act, 1948. The exercise will be conducted in under the House Listing Operation, HLO, April to September 2026. Population Enumeration, P. February 2027 across most of India. In Ladakh, Jammu and Kashmir, Himachal Pradesh, and Uttarakhand, enumeration will begin earlier, in October 2026, due to weather conditions. Reference date: for most states/UTs, midnight hours, March 1st, 2027. For Ladakh and snowbound/non-synchronous areas, midnight hours, October 1st, 2026. Budget and infrastructure. Budget estimate: the Registrar General of India, RGI, has requested 14,618.95 Indian rupees crore for the census exercise. Monitoring mechanism: a census monitoring and management system, CMS, portal is being developed for real-time supervision, ensuring timely and secure data collection. Bills and Acts. 130th Constitution Amendment, Bill, 2025 News. The 130th Constitution Amendment, Bill, 2025, introduced by the Home Minister, has been referred to a joint parliamentary committee. About 130th Constitution Amendment, Bill, 2025. The bill seeks to amend Articles 75, 164, and 239AA of the Indian Constitution, which deal with the Union Council of Ministers, State Councils of Ministers, and the special administrative provisions for Delhi. Key provisions of the bill. Article 75. Union ministers: a union minister arrested and detained for 30 consecutive days for an offense punishable with 5 or more years of imprisonment, removed by the President Prime Minister's advice, must be on the or will automatically cease to hold office if no advice is given by the 31st day. Reappointment is permitted after release from custody. Note: this also applies to PM Article 164, State Ministers. Similar provisions apply to Chief Ministers and State Ministers, with the Governor responsible for removal. Article 239AA, Delhi, extends the same rules to Delhi's Chief Minister and Ministers, with the Lieutenant Governor, LG, empowered to remove them. Government of Union Territories Act, 1963, applies the rule to Union Territory Ministers, empowering the Administrator/LG to act similarly. Jammu and Kashmir Reorganization Act, 2019, extends these provisions to Jammu and Kashmir, Lieutenant allowing the Governor to remove the Chief Minister and Ministers under the same framework. Jan Vishwas, Amendment of Provisions Bill, 2025 News. Recently, the Jan Vishwas, Amendment of Provisions Bill, 2025 was introduced in the Lok Sabha. About the Jan Vishwas, Amendment of Provisions Bill, 2025. This bill builds upon the success of the Jan Vishwas Act, 2023, which had decriminalized 183 provisions across 42 central acts administered by 19 ministries and departments. 2025 Bill 16 Central Acts under the further expands these reforms to 10 ministries/departments, replacing rigid and punitive rules with simplified, trust-based processes. Objective: to streamline procedures, reduce litigation, and create an enabling environment for citizens and businesses. Key features of the bill. First-time violations. For 76 offenses across 10 acts, first-time breaches will attract only an advisory or warning instead of punishment. Decriminalization of minor offenses. Imprisonment provisions for minor, technical, and procedural defaults are removed and replaced with monetary penalties or warnings. Acts such as the Tea Act, 1953, and the Legal Metrology Act, 2009, already amended in 2023, are further decriminalized. Rationalization of penalties. Fines are proportionate, with incremental penalties for repeated offenses. The bill also provides for an automatic 10% increase in fines every 3 years, ensuring their continued deterrent effect without requiring frequent legislative amendments. Adjudication mechanism. Designated officers are empowered to impose penalties through administrative processes, enabling quicker resolution of cases and reducing the burden on the judiciary. National Sports Governance Bill, 2025. News. The central government tabled the National Sports Governance Bill, 2025 in the Lok Sabha to reform and modernize the governance structure of sports administration in India. About National Sports Governance Bill, 2025 key features. Establishment of statutory sports bodies. National Olympic Committee, NOC designated as the sole governing body for Olympic sports in India. National Paralympic Committee, NPC sole authority for governing Paralympic sports in the country. Other federations. The bill formally recognizes national sports federations, NSFs, and regional sports federations, RSFs, to streamline governance at national and regional levels. Creation of the National Sports Board, a statutory regulatory body, similar to SEBI, responsible for overseeing the functioning of all sports federations, including the BCCI, empowered to grant recognition to sports bodies and enforce uniform governance standards. Will register all affiliated units of national sports federations, NSFs. 2. Ensure transparency and coordination. Equipped with budgetary support and capacity to hire domain experts in law, auditing, and governance. Setting up of the National Sports Tribunal, an independent dispute resolution body with powers equivalent to a civil court, headed by a chairperson, a sitting or retired Supreme Court judge or Chief Justice of a high court, along with 2 members with expertise in sports, administration, and law. Responsible for adjudicating disputes related to athlete selection, federation elections, governance matters. Appeals can be made only to the Supreme Court. Civil courts will have no jurisdiction over matters covered by the tribunal. All expenses to be met from the Consolidated Fund of India. National Sports Election Panel. A dedicated panel to ensure free and fair elections for the executive and athletes committees of all recognized national sports bodies. Age and tenure norms for administrators. Upper age limit raised to 75 years. Removal of fixed tenure restrictions to enable Indian administrators to secure leadership roles in international sports bodies, bringing the BCCI under the regulatory framework. Though traditionally outside the ambit of government oversight, the bill proposes to bring the Board of Control for Cricket in India, BCCI, under its regulatory scope. Once enacted, the BCCI must obtain official recognition from the National Sports Board. Any disputes involving the BCCI will be handled by the National Sports Tribunal. However, the bill keeps BCCI outside RTI since only sports bodies getting government funds are treated as public authorities under the Act. Promotion and Regulation of Online Gaming Bill 2025. News. The Union government has taken a decisive step to regulate India's fast-growing online gaming sector with the introduction of the Promotion and Regulation of Online Gaming Bill 2025. About the bill. Nodal Ministry, Electronics and Information Technology Objective. Promote esports and socially beneficial games. Ban online money games, gambling, and betting. Protect users, especially youth, from fraud, money laundering, and addiction. Encourage responsible growth and innovation in India's gaming industry. Key features. Definition. Online money games involve users paying money or stakes, credits, coins, tokens, expecting monetary or other enrichment, whether skill or chance-based. Prohibition. Offering, facilitating, or advertising online money games is banned. The government can block related information. Promotion. The central government can support and recognize esports and online social games. National Regulator. A national online gaming authority will register and categorize games, address grievances, and ensure compliance. Penalties. Operating/facilitating money games. Up to 3 years imprisonment plus 1 Indian rupee crore fine. Advertising banned games. Up to 2 years plus 50 Indian rupees lakh fine. Financial facilitation. Similar penalties as of operators. Repeat offenses. Up to 5 years plus 2 Indian rupees crore fine. Most offenses are cognizable and non-bailable, allowing enforcement agencies to act without a warrant. Forest Rights ACT 2006. News. Tribal representative body complains that the Andaman and Nicobar administration gave a false report stating that tribal people's rights under FRA were identified and settled. About Forest Rights Act 2006, also called the Scheduled Tribes and Other Traditional Forest Dwellers, Recognition of Forest Rights, Act 2006. Key legislation recognizing the rights of forest-dwelling scheduled tribes, STs, and other traditional forest dwellers, OEFDs, over land and forest resources they have traditionally depended upon. Nodal Ministry, Ministry of Tribal Affairs aim to recognize and vest forest rights in forest-dwelling STs and OEFDs. Objectives. Correct historical injustices against tribal and forest-dwelling communities. Ensure rights to livelihood, habitation, and access to forest resources. Promote ecological sustainability by involving these communities in forest protection, conservation, and management. Key features. Recognition of rights. Grants forest rights and occupation over forest land to FDSDs and ODFDs residing in forests for generations, previously unacknowledged due to colonial policies. Types of rights. Title rights. Ownership of forest land being cultivated up to 4 hectares, no new lands granted. Use rights. Access to minor forest produce, fodder, fuel, bamboo. Grazing areas, fish, and water bodies. Relief and development rights. Protection from eviction and access to rehabilitation and basic amenities. Community and management rights. Right to protect, regenerate, and manage community forest resources while preserving traditions and habitat. Gram Sabha's role. Initiates, receives, and verifies claims. Decisions are processed through subdivision and district committees. Community empowerment. Empowers forest dwellers to use and manage forest resources, protects them from unlawful eviction, and allows basic infrastructure facilities as recommended by Gram Sabhas. Foreign Contribution Regulation Act, FCRA. News. The Union Home Ministry has cancelled the FCRA, Foreign Contribution Regulation Act, license of the Students' Educational and Cultural Movement of Ladakh, SECML. About Foreign Contribution Regulation Act, FCRA. The FCRA was originally enacted in 1976 during the emergency to regulate the acceptance and use of foreign contributions by individuals, associations, and organizations in India. Its key purpose is to ensure that foreign funds are used only for legitimate purposes and do not harm India's national interest. Amendments. The law was comprehensively revised in 2010 and further amended in 2020 to strengthen transparency and accountability in the use of foreign funds. Validity and renewal. Registration under FCRA is valid for 5 years. NGOs must apply for renewal at least 6 months before the expiry of their license. Key provisions of the 2020 amendment. Suspension. The Ministry of Home Affairs, MHA, can suspend an NGO's FCRA registration for up to 360 days if violations are found. Mandatory Aadhaar. Aadhaar identification is compulsory for office bearers, directors, and key functionaries of NGOs. Public servants barred. Public servants cannot receive foreign contributions. Administrative expenses. NGOs can use only up to 20% of foreign funds for administrative costs, earlier limit, 50%. Ban on subgranting. NGOs cannot transfer foreign funds to other NGOs or entities. Designated account. All NGOs must maintain a dedicated FCRA bank account at the State Bank of India branch in New Delhi. Prohibited activities. Applicants must not represent fictitious entities, indulge in religious conversions, or have a history of communal tension, disharmony, or seditious activity. Foreign contributions are prohibited for candidates in elections, journalists, media organizations, judges, government servants, politicians, and political parties/organizations. National Security Act, NSA. News. Climate activist Sonam Wangchuk, who has been leading the demand for Ladakh's statehood and 6 scheduled safeguards, was detained under the strict National Security Act, NSA. About National Security Act, NSA, of 1980, it allows preventive detention to protect national security, public order, and essential services. Key features. Grounds for detention. A person can be detained if their activities threaten India's defense, foreign relations, or state security. It also applies to smuggling, disrupting essential services, or creating communal tensions. Procedure. Both the center and states can issue detention orders. The order must state clear grounds and be based on the government's subjective satisfaction. The detained person must be informed of the reasons. Within 3 weeks, an advisory board is set up to review the detention. Period of detention, initially up to 12 months, can be extended further, but each extension cannot exceed 12 months. Safeguards. The detainee has the right to submit a representation against detention. The advisory board examines it and advises the government, which may revoke or continue detention. The detainee can be represented by a lawyer before the board. Judicial review. The detention order can be challenged in the High Court through a habeas corpus petition to the point term/initiatives in News Savasar AI tool. Context. The center will launch Savasar, an AI tool to auto-generate Gram Sava meeting minutes. About Savasar AI tool launched by Ministry of Panchayati Raj, first rolled out. Tripura on Independence Day, August 15, 2025 platform. Built on Vashini, the government's AI-powered language translation platform. How it works. Panchayat officials log in through eGram Swaraj portal. Upload Gram Sava video/audio recordings. The tool generates transcription from a video or audio, translates it into a chosen output language, and prepares a summary. Language coverage. Supports all major Indian languages: Hindi, Bengali, Tamil, Telugu, Marathi, Gujarati, etc., along with English. Anjakar 2025 campaign. Context. The Minister for Housing and Urban Affairs has launched the Anjakar 2025 campaign. About Anjakar 2025 purpose. A last-mile outreach campaign aimed at creating awareness about Pradhan Mantri Awas Yojana, Urban 2.0, PMUIU 2.0, and its benefits among eligible urban households. Launched in 2024, PMUIU 2.0 aims to provide all-weather Pakka houses to eligible urban households, supporting the government's vision of housing for all. Duration of campaign, 2 months. Article 304 of Indian context. The Supreme Court of India has ruled Constitution that taxes cannot discriminate against goods coming from other states under Article 304A of the Constitution. About Article 304, it allows a state or union territory to levy taxes on goods coming from other states or UTs. However, it prohibits discrimination between imported goods and similar goods produced locally. Model Youth Gram Sava MYGS. Context. The center plans to launch Model Youth Gram Sava MYGS. About Model Youth Gram Sava MYGS. Purpose. School-based initiative inspired by Model UN, aiming to educate students on local governance and democratic functioning. Participants. Students of classes 9 to 12 will play as Sarpanch, ward members, village secretary, Anganwadi worker, junior engineers, etc. Activities. Conduct mock Gram Sava meetings, discuss local issues, and prepare village budgets and development plans. Implementation. Phase 1. Over 600 Jauhar Navodaya Vidyalayas and 200 Eklavya model residential schools from October 2025, also in selected Zilla Parishad schools in Maharashtra and Karnataka. Phase 2. Rollout to state-run schools. Implementation, led by Ministry of Panchayati Raj with Education and Tribal Affairs Ministries. Commonwealth context. The Lok Sabha Speaker inaugurated the Parliamentary 11th Commonwealth Parliamentary Association, CPA, India Region Conference in Bengaluru. About the CPA, It is one of the oldest organizations in the Commonwealth, providing a platform for parliamentarians to collaborate and share best practices. Founded, 1911 membership, over 180 legislatures/branches, including India. Headquarters, Houses of Parliament, London, UK, Sahयोग portal. Context, the Karnataka High Court has recently dismissed X-Corp's petition against the Union government's Sahयोग portal. About Sahयोग portal purpose. Sahयोग is a centralized platform that integrates authorized agencies, including police, and intermediaries to facilitate the removal or blocking of information, data, or communication links used to commit unlawful acts. Launched by Ministry of Home Affairs, MHA. Maintained by Indian Cyber Crime Coordination Center, I4C, legal basis, developed under Section 79(3)(b) of the Information Technology Act, 2000.